Good afternoon, everyone. I'm very glad to, well, virtually see you. Obviously not see you in real life, but to virtually see you as one does in this year. And especially also to see so many of you on a session on intellectual property rights and open data on a legal topic, which is, well, it's not that common that legal topics generate a lot of visibility and a lot of focus. So I'm very happy to see that there are a lot of exceptions to this rule. You are right to be here, though, because there are a lot of interesting topics and a lot of interesting evolutions going on right now. And in this session, which will be split into two parts. In this session, the idea is to, first of all, to summarize some of the main trends, some of the main evolutions, and also have an open panel discussion. So in terms of agenda, let me see. There we go, that should be working. In terms of agenda, so I'll start off with a short introduction to the main topics that I want to discuss, the main context, policy context and legal context, what's actually going on and why are we talking about intellectual property rights right now, even though intellectual property rights are not a buzzing hot topic in and of themselves right now. I want to talk about two things in particular. First of all, a quick presentation and the discussion on the Open Data Directive. So the innovations that it's brought on board there, and that the Open Data Directive, for the purposes of this presentation, is kind of an appetizer for the second and bigger meta topic, I would say, of the presentation, which is the shift that we're seeing right now, not just in the market, but also increasingly in public sector and in data economy in general, and society in general, from static data sharing to data as a service. And what that actually means, what that entails, also from an intellectual property rights perspective, to have new possibilities, to have new constraints, what you have to look out for. So really, we have kind of two big themes that will run through the presentations that we have ready here today. First is the data economy, the emergence of the data economy itself, the whole policy agenda behind it, the whole narrative that data sharing is a good thing and we need more of it as a European economy to be able to compete in the global market. And the second part of it is the resulting shift to dynamic, flexible, live, real-time data sharing. Those presentations that we will have in the first hour, I'll try to leave some margin in both presentations for questions afterwards on the topics themselves. We'll have those presentations in the first hour, and then afterwards we'll have an interactive, more dynamic section of the presentation itself, for which we've invited a couple of very skilled and very knowledgeable panelists. That will be Ms. Annette Hillebrand from WIC Consulting and Mr. Ton Zijlstra from Geonovum. Unfortunately, we also had invited a panelist from the JRC, but she was unable to attend since, as some of you might be aware, the API Days conference in Paris is also ongoing and overlapping. Nonetheless, I'm sure we'll be able to have an interesting panel discussion with the people who are present. And you're also encouraged after the presentations in the first hour during the panel discussion to raise your own questions, because the idea, obviously, with this being a training session, is that we answer your questions and not that we project our questions and our answers onto you. So do feel free to raise questions after the presentations or at any time during the panel discussions. You can do that by unmuting and asking it directly. I will also keep an eye out for questions that pop up in the chat after the presentations and during the panel discussions, for those of you who would prefer not to speak up while recording. As was already mentioned, you will get a copy of the slides, so feel free to make screenshots if you like, but there's no burning need to do so. And I've also provided the link on the slides themselves to one of the discussion documents that was prepared in the context of the Open Data Academy discussion paper on intellectual property rights in the context of dynamic data sharing. So one of the topics that was the input for the session today. Okay, so having said that, let's maybe briefly pause to think about what is actually the context. Why are we talking about this? And The reason why it's interesting to talk about intellectual property rights and dynamic data sharing right now is all about how the data economy is changing, both in the market and in European policies and European legislation. Because there is a, thankfully, as the way it's supposed to happen, this is one of the situations where the legislation is very well aligned with market trends and market shifts itself. What you see in the market itself is that increasingly everything is made available as a service. That's, you know, the cloud paradigm started introducing that shift 10 years ago, and nowadays everything has to be as a service. Yeah, software as a service was arguably where it started, infrastructure as a service, platform as a service. Nowadays also data as a service, mobility as a service, anything can and according to some people should be available as a service. In tandem with that, we also see that there is increasingly a possibility to capture higher volumes of data, more granular data, better quality data, and that we can do more interesting things with that. I'm sure many of us frequently watch the data being captured, for instance, in the context of COVID-19 crisis. You know, where are there infections? How is hospital occupations? Things like that that are very relevant, and also a good example of why data sharing becomes important, and what the role of the EU can be even on that point. The European Union does bundle information on the health status in different member states and uses it to provide guidance on, you know, where the risks are in moving across borders and what specific measures apply. Obviously, that's a negative example, but positive examples of societal impacts can be given as well. Things like keeping track of pollution data that'll help you track on whether we are meeting our environmental targets, what still needs to be tightened up. All of those are cases where more and more data is being collected, supported by increasing digitization of the market, the penetration of the Internet of Things and so forth, the ability to collect more data and to share it more freely. We also see more that, you know, more data is available, and the more dynamically it is accessible, the more you can get access to real life, high quality data, the more innovation you can get, more easily you can disseminate knowledge and information to citizens, to companies, to public institutions. So this is hugely beneficial from a societal perspective, creates economic growth opportunities and results in better policy making. The overall conclusion, the overall conviction is data sharing is good for everyone, for the European data economy, but also for citizens and for public administrations. That's essentially the conviction that underpins the European strategy for data as a policy framework for data sharing within the European Union. Consideration that society will work better if more data can be shared between relevant stakeholders, of course, with full respect for European values, European standards, and European legal frameworks, which includes obviously also intellectual property rights. And we've had a lot of legislative initiatives recently. As a lawyer, it's very exciting to watch how quickly that landscape is changing. Obviously, we've had the Open Data Directive, on which I'll talk a little bit more in the session. But there's also a bunch of upcoming and emerging legislation that will affect data policies and data sharing possibilities in the European market. The Data Governance Act is a fascinating new framework for altruistic data sharing. That the Digital Services Act that will govern how intermediary platforms are expected to act, the Digital Market Act that aims to address some of the imbalances that you have with dominant platform operators. We have the Expected Data Act, which among other points aims to underpin the fairness of data sharing and support a reasonable contractual framework. We have an ongoing evaluation of the Database Directive, which might result in some overhauls. It's still to be seen what will come of that. So this isn't something that's just happening in society. This isn't something for which interesting policies have been written up. It's also something that's actually reflected in legislation. So it's important to keep close track of how the legislation changes and what the impacts are going to be. And this particular session, we want to look in particular what the impact is on intellectual property rights. Now, as a first topic in the presentation sessions, I just want to spend some time on the Open Data Directive. Most of you, or at least many of you, I assume, will be familiar already with the Open Data Directive and how it works. But especially as a I guess you can think of it from our perspective as an appetizer for the second theme, which is more about data as a service and how that affects intellectual property rights. Here I want to talk about the role of open data, of the Open Data Directive in that general trend. How does the Open Data Directive support the data as a service data shift, and how does it approach challenges in relation to intellectual property rights? So I'll try to be as brief as I can on the Open Data Directive. There's a lot of ground that can be covered, so I'll try to be a little bit modest because not everything is relevant to intellectual property rights. But it's important to get a grasp of how the Open Data Directive works, because it is one of the instruments that most emphatically and most drastically underpins dynamic data sharing in the European Union today. So the Open Data Directive, it's directive in 2019 on open data and reuse of public sector information, which I guess most of you will be aware is a recast and a modernization of the existing PSI legal framework. So we've had for a long time already had legislation in the European Union on public sector information, documents, information held by public administrations, by the public sector, and on the principle that this data can be made available to citizens and to private companies for commercial and non-commercial use. That's been a long-standing conviction, that data sharing and that making available governmental information, which was taxpayer funded, to citizens and to businesses, that is a beneficial thing already. So we've had that legislation in place since 2003. It's been modernized already, and this is the Open Data Directive is the most recent recast of that. And it's interesting to see sort of just what the general logic is, what the general flow is between each of the recasts, each of the evaluations, and each of the modernizations. The general trends that you see, and I'll pick up on a lot more details later on in the further presentation of the Open Data Directive, is that the scope of what falls within the reach of the directives is extended. More types of reuse are permitted, so that basically more data should be made available in more situations. We also see that the directive becomes progressively more prescriptive on how data sharing should occur, what kind of practical modalities should be supported. So that's not just about licensing modalities, about transparency towards aspiring reusers, non-discrimination, banning exclusivity arrangements, making sure that licensing conditions, if any, are fair, regulating the pricing that can be applied when sharing public sector information. All of those points increasingly become a little bit more detailed, and the most recent version, and we'll talk a lot more about that later on, is focusing on a push towards dynamic data sharing, basically data as a service, as we're approaching it in this particular presentation. The general idea is always that data sharing from the public sector should be more free, more open, more conducive to innovation, and more conducive to encouraging, enabling innovation and competition in the European data economy, which is also why it now got the objectively sexier name of an Open Data Directive, rather than just calling it the next Public Sector Information Directive, PSI 3, which would also have been valid. So it was adopted in 2019, had to be implemented by the 16th of July 2021. Sorry, there's a one missing on the slide, 2021. So member states were required to implement this legislation already and to notify the Commission. I'll revert to that in a moment. So this is the main legal framework that encourages member states or requires member states to move towards a dynamic data sharing model. So how does it do that? How does it innovate? I'll try to be a little bit brief here because there are a lot of things that you can point out as being interesting, but I'll try to focus on the elements that are relevant to the IPR discussion. So one of the biggest innovations, arguably the biggest one, is that the Open Data Directive focuses specifically on high-value data sets, so-called high-value data sets, which basically is described as documents that create important benefits for society, environment, and the economy to be reused. So this is basically the elements where the European legislator, the data sets where the European legislator has said, this is particularly impactful. We have to make sure here that this data becomes available to as many parties as possible under as easy easily accessible and dynamic terms as is realistically feasible. Specific categories of high-value data sets are mentioned in an annex. So I've listed them here and included a couple of examples that I won't go into now. But they include geographic information, Earth observation, meteorological data, statistics, company data like business registers, company ownership, and mobility data, including road signage. All of those kinds of data sets, which are not maybe as intuitively exciting, but all of which have broad availability in a lot of member states, and all of which offer a lot of direct benefits to social goals. So these are data sets that are listed in the Open Data Directive, and which can be expanded also by the legislator. So this is a set of data that can be amended by a delegated act by the European Commission itself to incorporate new types of data that might be extremely impactful. I would imagine, if this directive had been adopted 2 years later, that, for instance, epidemiological data might be included in that high-value data set. So this is the kind of information that is included, and the reason the method why these data sets are targeted in particular. So the specific rules created for these high-value data sets, which are not universally applicable to all kinds of public sector information, is that data has to be available free of charge in machine-readable formats through APIs and, where relevant, as bulk downloads. Through the use of application programmers interfaces, making this information available through dynamic services upon request is the main part where the dynamic and the flexible element comes in here. So the idea here is very much that you don't just get to download a CSV file or an Excel file or a static file itself, but that you actually are able to access specific interfaces that allow you to integrate this information, this kind of data, easily into a specific software package or in a specific service or in a specific product even. So the goal is to make sure that that data is available easily and flexibly. There are some exceptions to that principle, which I won't go into here, which mainly reflect cases where fully free distribution without any kind of compensation would have unreasonable negative impacts. But the general principle is that these kinds of information should be freely available. I see there's a question in the chat on the questions that open data raises on business and research competitive advantages. I'll look a little bit at the research approach in the Open Data Directive later on, and then if there's a specific question, I guess we can tackle that later on competition points. There's another comment I see in the chat already that business registries are very important, especially because there's a market behind that. I'll wrap up the presentation first, but I have a lot to say on that particular issue myself. The bottom line is that I agree with that, but there are some sensitive politics behind that. Let me focus first on what is in the Open Data Directive, and I'll get to the questions as soon as we're done with that part. Scoping of the Open Data Directive is also extended. So explicitly, libraries, including university libraries, museums, and archives, are entered into the scope of the Open Data Directive, and also public undertakings, which is another relevant, very relevant extension of the scope of the Open Data Directive. Public undertakings are basically all of those gray area situations where a company is not entirely a public sector body, but nonetheless is under substantial control by the government or by a public administration, because the public administrations provide most of the funding or have control over the management boards or have some other way to directly or indirectly influence how a company is managed. The examples given here, I think, are pretty intuitively recognizable. Water companies, energy, transportation, rail, air carriers, postal services, all of those might be fully or entirely privatized, but in a lot of member states, you will have stakeholders there that are extremely heavily subsidized or otherwise under governmental control. So in those cases, those documents held by those kinds of undertakings are brought into the remit of the Open Data Directive as well, which is important because some of that information obviously is extremely valuable, and ruling that as being unilaterally out of scope of the Open Data Directive very much limits the impact of the directive, also for high-value data sets, because a lot of high-value data sets are held precisely by public undertakings. There's also an extension of the scope, and this begins to touch on the question that was raised in the chat on research data that results from public funding. It's actually kind of a comparable issue, a comparable topic that I mentioned earlier. Part of the whole thinking of public sector information legislation is that this information is funded through taxpayer money and aims to serve the public good. That's why public sector money, why taxpayer money is spent on it, because it aims to achieve public good. If that is done, then arguably the data should also be freely available, not necessarily to all taxpayers, because everything that the government does fundamentally is taxpayer funded. But at any rate, there's a stronger argument to be made that information like that should not be hoarded, or at least that there's also societal benefit in making that data more freely available and allowing more parties to benefit from that. And that's especially true for publicly funded research. The EU and the member states fund a lot of research sensibly, creates a lot of benefits for private companies, but also for citizens, for innovation, for the European economy as a whole. But it's kind of a shame if you allow that kind of information, publicly funded research, to stay private within the organizations that originally generated it, because that limits what will be done with it and how much you can build on that. So on that point, the Open Data Directive requires member states to implement open access policies, integrate open by default principles, fair principles, to make sure that research programs include this kind of data sharing by default. Those of you who might participate in European funded research know this already. The EU has already had open access policies in the Horizon 2020 program and also in Horizon Europe right now, which means that anything that the EU funds in principle must be openly available. If you want to keep data closed, for instance, because there are data protection problems, then you have to justify that. But the open by default is a baseline requirement, and that's an example of a policy where research data is required, or at least very much encouraged, to be openly available. Rules on charging are also tightened up in the Open Data Directive, and that's a very interesting one, because the principle has always been that you can only charge at most marginal cost. There's always been an encouragement to make data available as cheaply as possible, and in a digitized society, marginal cost either is zero or at least always trends towards zero. Marginal cost is just, the cost of making and disseminating an additional copy. In a digital environment where you can easily copy any kind of data and send it virtually for free, the marginal cost is always very close to zero. The Open Data Directive is very explicit on that point and says free reuse is the basic principle. So in principle, when data has to be made available for reuse, you cannot charge for that. You are allowed to apply some marginal costs specifically for reproduction, provision, and dissemination of documents, but it has to be justified. You have to explain why a marginal cost applied for reproduction and for providing and disseminating documents, which is not easy to do in an electronic context. If you already have data in a digital format, then making it available for reuse basically should have a marginal cost that is either literally zero or at least very, very close to zero. There are some exceptions to that, for instance, for anonymization and protection of commercially confidential information. If you need to anonymize information or edit out some sensitive components, then that is something that you can apply a marginal cost for. It cannot be part of your business model, cannot be a part of the profit model, so to speak. There's no profit model is supposed to apply there, but that at least is a cost that you can charge onwards. There are also some narrowly defined exceptions for public administrations that require dissemination, that require funding from making information available to basically be able to fund themselves. There's also a broader carve out for libraries, museums and archives, and again for public undertakings who may not be required to make information available for free. So that is a bit of a nuance to that general principle. The general push, though, is very much that information should be made available for free wherever possible. There are also, and that's where I'll wrap up the Open Data Directive presentation section. There's also a much stronger push generally towards providing real-time data and APIs. So making data dynamically available through application programmer interfaces, through dynamically accessible services upon request, that's already mandatory for the high-value data sets that I mentioned earlier. But more generally, the Open Data Directive also has a principle that there's an obligation to provide information via APIs for dynamic data, which has a specific definition that I've listed on the slides here. It's basically any kind of documents that are frequently updated or updated in real time. Basically, if data is constantly changing or in flux because of this volatile, rapidly obsolescent, for instance, things like traffic information, which changes all the time. That's the kind of information that can be collected in real time, that is updated frequently, and for which a lot of the value stems precisely from the fact that it's up to date. Getting historic traffic data is interesting for research purposes, but to build really valuable applications, you need information that's as accurate and up to date as possible. For those kinds of dynamic data, including most types of sensor capture data, the Open Data Directive has the principle that public sector bodies and public undertakings have to make dynamic data available immediately after collection via suitable APIs. Can also make it available if that's relevant bulk download, but there is in principle a push towards APIs, towards data as a service, basically. The Open Data also has some interesting points to make on how licensing should occur where licenses are used. So you are not required as a member state or as a public administration, you're not required to apply legal conditions and to implement legal agreements on reuse of your information. You are allowed to make information available fully openly without any kind of legal constraints. It's not very commonly done, but in some member states that approach is occasionally favored, where public administrations basically say, I have data, I will put it on my website and you can have it and you can do what you want with it. I don't want any kind of formal agreement with it. Obviously, you need to respect the law, whichever the law is that applies to you, but I'm not going to have any explicit kind of license agreement. The Open Data Directive doesn't require licensing agreements to be applied, but if you do, member states are encouraged to apply standard licenses so that you don't have to do your legal homework on a case-by-case basis. Also important from an intellectual property rights perspective, that you have some clarity on the kind of frameworks that are out there. There's also an obligation for those licensing practices, licensing modalities, to not impose conditions that are really necessary on the basis of public interest. They have to be transparent, it has to be proportionate, it has to be objective if you want to impose specific restrictions, for instance, on permissible use there. Member states are also encouraged to implement some practical arrangements, so facilitating document searching through portals and things like that by publishing metadata as well to make it more easy to read and interpret data and to integrate it into specific applications and to provide portal sites. So the general trend, the general narrative here is that the Open Data Directive requires member states to make more information available and to make it more dynamically available. The fact that they are pushed towards an API-based model, not for all types of data, but at least for the more high value and the more impactful types of services, is important in encouraging a kind of a mind shift for member states and making sure that they consider, whenever they have information, whenever they have data resources, that they can consider how can we allow the biggest value creation on that. Not necessarily, how can we integrate on a one-to-one basis and establish mature business relationships with a closed field of privileged stakeholders, but really to say, how can we open this up and to make sure that citizens and companies and other public administrations can create more benefits and create more advantages on this. So that's a big part of the red thread of the Open Data Directive. Member states had to implement it by July of this year. There's an overview available maintained by the European Commission on implementation measures. The existing PS or new PSI legislation has been implemented. A couple of member states, 12 states, which is quite a lot, have aligned their legal framework for public sector information reuse and access to documents. So transparency of the public sector, which is a topic that's not harmonized at the European level. Some member states roll them together. So measures have been taken in most of the member states. However, there has been an announcement on 30th of September that the Commission opened infringement procedure against 19 member states who failed to notify the European Commission, which in some cases is just a matter of, as I understand it, of paperwork, that the modifications have been implemented but not notified to the member states. In some cases also the measures have been insufficient to comply with the requirements of the open, or are potentially insufficient to comply with the requirements of the Open Data Directive. So the link with intellectual property rights, and here's where I kind of want to start making the bridge to the second topic, the dynamic data and the data as a service part. The Open Data Directive as such doesn't contain any exceptions to intellectual property rights, so no copyrights are declared invalid, and you don't get exceptions to copyright or to database rights. In fact, it explicitly states on a couple of occasions that intellectual property rights of third parties are not affected by the directive, and that documents for which third parties hold intellectual property rights are not forced under the remit of the Open Data Directive. Doesn't mean that you're not allowed to do anything under national public sector information legislation for those types of documents. The Flemish region in Belgium, this legislation has been amended in a more flexible way, and basically says that reuse still has to be permitted if it's compatible with third-party intellectual property rights. Intentionally saying, even if a third party does hold intellectual property rights, we get that we don't have to make it accessible under the Open Data Directive, but nonetheless, reuse is encouraged unless it would violate those third-party rights to permit reuse. So you can take a more broad perspective on open data reuse modalities. So there's no explicit exceptions, no explicit carve-outs from intellectual property legislation in any part of the Open Data Directive. But obviously it is very intrusive and impactful, or aims to be very impactful on the practical modalities behind open data sharing for PSI. There is a greater push for openness, expansion of the scope, more emphasis on fairness, and more emphasis on flexibility for reuses. That's what I wanted to say about the Open Data Directive. I'm going to quickly cast an eye on some of the questions and some of the comments that have been made before I start on the second part of the presentation. So there's been a question raised, I mentioned already earlier, the challenges that open data raises on business and research competitive advantages. I slightly touched upon it with the publicly funded research provisions. It is challenging. I don't know if that's the idea behind the question. The risk is indeed that private organizations might decide not to accept public funding because it brings them within the remit of public access provisions, and it requires them to share their data under conditions that they might otherwise not like. So that is a potential challenge, a potential business impact. But generally, the perception of the Open Data Directive is that the net impact would be positive if you can create an ecosystem where publicly funded research is more broadly available for reuse. That would be considered beneficial. I mentioned already, I'll keep some of the open debates for the second interactive session, so I'll park some of these questions. I already saw the commented briefly on the issue that business registry data is indeed very important. It's an important topic also because it touches on a lot of other topics. We also have legislation, the IDAS regulation on identification of persons and identification of legal entities. Very difficult to do that if you don't have more easy access to company information and to company data. A lot of member states still struggle with that, in the sense that they only make company data available on a very limited scale or for a very high cost. So that is indeed a challenging one. There's a fantastic question I want to discuss about the geopolitical context. I'm going to park that, but I'm going to write that down because I definitely want to spend some time on that during the panel discussions. But the geopolitical context, and indeed the question whether the EU isn't weakening itself by handing out the crown jewels, is the criticism that you could levy against this kind of initiative. That's a very interesting one. I am going to note that down, so please don't forget about it. We will come back to it on the panel session. That was kind of the more legalistic appetizer. So for those of you who got bored because this is too formally legal for you, it does get better. The second topic that I wanted to present before going to the panel debate is the shift from static data sharing to APIs. Obviously, and I'll touch on that already in the context of the Open Data Directive, because at least the way I read it, it's one of the more interesting and one more fascinating shifts in public policy. So this also, for those of you who had the opportunity of reading the discussion paper that I linked on the first slide, this is also something that's happening in society in general. This is not a public sector information topic. This is not even an open data topic. Increasingly, everything is available as a service. The X as a service, whatever you want is available as a service. You can buy a car as a service even. It's not just mobility as a service anymore, where you can just pay a fixed model to be able to skip to be able to access buses and trains and trams. It's expanded to being able to temporarily rent cars for as long as you need them and get rid of them when you want. It's a very fascinating shift. And if you look at it in the digital context, specifically for data, but for any type of digital content, if you're old enough, you'll remember how this model has evolved. Don't have to be very old. Probably if you're over 35-ish, you remember that traditionally you used to buy things with a media carrier. You bought a floppy disk or later on a CD-ROM or a DVD. And the model was the idea, the sales pitch that you got was that very much that you own something. You bought something, music or a movie or software. You got a physical object. You actually had to go to a store for that. And then you owned it and you could resell it and you could do whatever you want with it. There's some nuances there, but that was the sales pitch. When the internet became quicker and more efficient, the model evolved. It was possible to buy a download instead. So you got no more physical item. You just downloaded, again, software or music or a DVD or raw data from the internet. You purchase a license with it, and your model, you wouldn't traditionally consider that as ownership anymore. You'd simply say, well, I'm a licensee. I'm a holder of a license to this digital content. The more recent iteration is the move to a service. You don't buy a static piece of software anymore. You buy a subscription to a specific software. You're an Amazon subscriber, you're a Microsoft subscriber, you're an Apple subscriber, you're a Google subscriber. All of those give you access to a service as long as you pay for it. Same thing, if you're a Spotify subscriber, that's where your music comes from, Netflix for your movies. All of these things you now buy under a subscription model. The legal model behind that, so I've put it sort of in hard columns on the slide here, saying that you want to go from ownership to license and subscription. It's not that black and white. You never, when you bought your copy of Windows 95 on floppy disks, if you remember that, that actually did exist for a short time. That never worked, but it did exist. Obviously, you didn't own intellectual property rights into Windows. You bought a license as well. You had material ownership of the physical carrier of the floppy disks related to the CD or the DVD, and you still had a license. So it's not like we went from a hard ownership case to a hard license case. There was more emphasis away from traditional ownership to licensing. That's important for the intellectual property rights perspective as well. I'll get back to that in a moment. Same thing with a subscription. Yes, it is presented to you as a subscription, as a service agreement that you sign up to. But still, if you get intellectually protected content, the copyright to that didn't magically disappear. And you still get a license to use the software, to look at the video, to listen to the music. So it's the sales pitch, the market pitch that you get isn't identical to the legal model behind it. But it is interesting to see that you get a shift away from ownership models to IPR license models to a more service-oriented model. It has implications as well. And you see also that this is a trend, the access to information, that there's more of an emphasis on access and usage rights and less of an emphasis on ownership and on licensing. You see that in various sets of legislation as well. Obviously, the Open Data Directive that I've already, I said enough about that already, the whole inclusion of APIs and data as a service and the emphasis on high value data sets. That's one example. But you see this preference for data access and usage models. You see that also in other legal instruments. I've mentioned a couple of them on the slides, just to show that this is a broader trend, that this attention of this legislator to dynamic data and to dynamic data access, to the use of APIs even. This isn't something that was invented just for the PSI context. This is something that more broadly affects European data policies. In the banking context, you have the Payment Services Directive 2, the PSD2 directive, that requires banks or financial institutions to make certain account data available via APIs to third-party payment service providers and account information service providers. That's precisely to enable the app economy and to make a harder split between traditional banking services and all of the applications and services that can be built around that. There are obviously safeguards around that. Your account information doesn't become open data and doesn't get thrown on the streets. There's requirements for authentication, for gathering consent, for evidence, for showing you're compliant with that. It's not exactly a lightweight framework, but it is a framework that emphasizes the importance of data sharing and of dynamic data. The energy legal framework, and specifically the electricity legislation, has also been amended to that point. We all know we will need to move at some point, whether we like it or not, to smart metering and to smart grids, smart networks. It'll be necessary for the decarbonization of society and for innovating smart electricity management. That also means that we as consumers need to have smart metering systems in our home. And to be able to use those to the fullest, we need the data on those systems to be not open to everybody, but at least there needs to be a model behind that to share that data, to make it available via APIs, to make it available via services, so that you can take your smartphone and connect that to your smart metering system and determine whether your car should be charging right now or whether it should be decharging. You can keep an eye on whether your solar panels are going to be used to consume electricity now or whether you want to charge it in your smart battery station. All of these kinds of things where you want to analyze, manage your electricity responsibly, hopefully at some point fully automated, because I don't think many of us will have the appetite for that. But all of it will require data sharing and APIs. So that's another example of legal frameworks that focus very much on enabling dynamic data access, data as a service. The automotive industry has known this for quite a long time already. Vehicle repair and maintenance information. I mean, we all know the sales pitch, and for most of us, we've experienced it already. If you have a car that's not too old, a car is essentially a very big computer with wheels under it. It has a lot of sensors in it, collects a lot of information, a lot of smart and useful information. But if your car manufacturer and the authorized dealers are the only ones who can get access to that information, that's not good. That's not good for innovation. That's not good for competition. If nobody can check anymore what the error codes of your car mean without paying a license fee, that's a problem. So this is also one area where the European legislature intervened and said, well, this kind of basic information, which is necessary for vehicle repair and maintenance, that has to be made available via an open interface, even to independent car dealerships. Not for free. A fee can be charged for that. Again, it has to be a marginal fee. So there's no hard obligation that this kind of data sharing always has to be gratis without any kind of costs, but there has to be a recognition that competition and innovation have to be possible here. So we see that this entire shift, this entire emphasis on data sharing and accessibility, that comes back in a lot of legal frameworks, and none of those talk very much about intellectual property rights, but that also kind of touches on one of the major points that I want to look at here in the session about IPRs, because this is something that gets misunderstood quite frequently, and it results creates a lot of problems as well in the data economy. Intellectual property rights have a very specific field of application, and what public sector information legislation never did was expand that. It also didn't undercut it. I mentioned that already. The Open Data Directive also doesn't contain exceptions or carve-outs to intellectual property rights, but they also never depended on it. If you look at how intellectual property rights affect open data sharing, and also in the public sector context, like at the Open Data Directive, there's actually some requirements that are not that trivial to meet for a lot of data sets. If you look at copyright, in order to be able to say that your data is protected by copyright and therefore that you need a copyright-based license for that, it means that you need to satisfy the originality requirement. Data that you want to be able to license under copyrights needs to show signs of the originality, the creativity of an individual creator. Doesn't mean that it has to be very artistic or extremely unique or anything like that, but there does have to be a sign of originality, of personal individual input, personal creativity from a specific person. Especially in public administration, that's not so trivial to meet. For most of the high value data sets that we mentioned, that's objective data, that's observational data. It's very valuable data and a lot of money is invested in it, but it's not original data. There's no creative input in the selection of that data and the organization of that data. It's all relatively objective. For most of that data, copyright does not apply. Now, if you hear that entire explanation, then intuitively would say, well, we also have database directive in the European Union, very EU-specific instrument. Not all, most jurisdictions don't have anything that's directly comparable to it. Where we basically have a directive saying that you can get, even if no copyright applies, independently from whether copyright applies, a database that you create can also receive protection, sui generis database right, if you made a qualitatively and quantitatively substantial investment. If you've invested a lot of money or effort or time in creating a database, then it's also protected by European intellectual property rights, but not by copyright maybe, but at least then under database rights. But that's also something that's been eroded gradually, and the impact has been lifted a little bit through a series of rulings from the European Court of Justice to interpret the scoping of database rights, basically saying, and I'm vulgarizing and I'm summarizing a lot, but basically saying that databases are not protected by those specific database rights, sui generis rights, if databases are just a natural byproduct of the main activity of an organization. So if you are a mobility service, if you are the railway company and you publish information about your train schedule, that's not subject to database rights. That's just a byproduct of the fact that you have to organize transportation. I'm sure you did and do invest a lot of effort and a lot of time. You invest a lot in keeping that information up to date, but you don't do that to create a valuable database. It's just a side effect of your main activities. And that also erodes a lot of the database protections, especially for the public sector, which as a general rule doesn't invest qualitatively and quantitatively in databases just for the purposes of having a valuable database, but which produces those as a side effect. Like the business registers mentioned earlier on, no government invests in database registers because they like to have a valuable database. It's because they need to have them to be able to do their public sector tasks. So intellectual property rights are less of a pillar of this kind of policy making, of the protection of data than people sometimes think it is. So doesn't mean that intellectual property rights are not valuable or that they are not important. And just to avoid misunderstandings, I am certainly not saying that intellectual property rights are not relevant in a public sector information context. It's just that it's not a universally applicable requirement. There's no hard law that says that any kind of valuable information has to be protected by an intellectual property right. And that is something that where sometimes people mix up the cause and consequences. This is also particularly important because when making data available as a service, so in the dynamic data context, the data as a service, API context, you don't need, strictly speaking, intellectual property rights to protect information or to impose restrictions and to make sure that you can steer a little bit on how it can be used, how it cannot be used. We actually had case law on that as well from the European Court of Justice. There are other rulings, but this is the main one that's been known. A case between Ryanair and PR Aviation, which essentially, again, I'm simplifying a little bit, but essentially Ryanair published their flight schedule on its website. PR Aviation was a company that screen scraped, or more or less, copied that information directly from Ryanair's website. And Ryanair alleged, among other points, that that was a violation of their intellectual property rights, that it violated their IPR rights and their database rights to that data, their flight schedule, which was available on their website. The European Court of Justice said, no, that makes no sense. And following basically what I said earlier, this isn't original data, it's just objective information, which flight goes from where to where, which date and which specific time. And that's not original, doesn't show any creativity, so copyright didn't apply. It also said that database rights, sui generis protection, also did not apply because Ryanair isn't investing in a database of its flights because it feels that it would be fun to have a valuable database. It's just a side effect of the fact that it needs to organize flights. That database just naturally happens. You cannot conduct your business as an air company without that kind of database. So no intellectual property rights. So was there no violation by PR Aviation? Was there no unlawfulness? Yes, there was unlawfulness, because despite the fact that no intellectual property rights existed in that database, there was still an infringement of the contractual framework, the terms and conditions that Ryanair published. Basically, intellectual property rights being inapplicable doesn't mean that you can't write your own constraints. You can write your own terms and conditions separate from any intellectual property rights, and publish those online, or whatever their chosen means is, to dictate on how your data can be used and cannot be used. And that actually has a couple of interesting consequences and a couple of interesting impacts. A lot of people in the open data community are kind of suspicious of intellectual property rights to begin with, because they are seen very much as a tool for constraining reuse, constraining accessibility, limiting access. Intellectual property rights are often seen as a negative factor, something that makes a particular kind of use impossible. That's actually a little bit unnuanced. Intellectual property rights, in some cases, depending on how they are applied, can actually be conducive to allowing openness as well. And even there too, I'd be very brief on that. We've had some interesting case law as well from the European Court of Justice, this European session, so I'm focusing on EU rulings. In the UsedSoft case, where the Court of Justice basically said that you are allowed to sell copyright licenses. This was a case where UsedSoft, as the name kind of suggests, sold used software licenses. So if you bought a software license, in this case from Oracle, you could use the services from UsedSoft to sell your copyright license to other customers. There was a lot of discussion saying, is that actually possible? Is a copyright license something that you can own and that you can sell? It's a very important question of principle. The Court of Justice said that under very specific constraints, which applied here, yes, it is possible to sell copyright licenses. Without going into too much detail, the main constraint is that obviously the person who buys the licenses from you had to be eligible for the license as well. So you can't sell your private license to a company, or the other way around, to sell a company license to a private consumer. They have to meet the same requirements. There's some other conditions as well, but this is something that you cannot forbid on the basis of copyright law. This is something that's lawful according to the European Court of Justice. If you don't have the crutch of intellectual property rights, of copyright protected data, or of database rights protected data, is that still possible? If you have if you accepted the terms and conditions and have a services agreement to use specific data, is that right as well? Can you sell your terms and conditions agreement as easily as you can sell copyright licenses? Honestly, that seems less likely. So this is an example, maybe a niche example, but still an example of where intellectual property rights are not a constraint on openness and on data sharing, but where they actually are an enabler as well. More generally, also under copyright law. Copyright law has a lot of exceptions and carve-outs for lawful users, where legislator basically said if you have access to IPR protected information, certain kinds of usage is lawful and does not require the permission from the rights holder, like, for instance, conducting research, academic research, educational tasks, the private home use exceptions. All of those are cases where you don't need permissions from the rights holder because they are predefined in intellectual property rights legislation. If that falls away, if there is no intellectual property right, then those protections disappear as well. So from that perspective, and looking at the bigger picture here, if you look at data as a service, dynamic data sharing, is that better or worse than an intellectual property rights-based framework? Kind of depends where you're coming from. The safeguards and the protections that have been predefined by the legislator in intellectual property rights, those fall away. So you can't avail yourself of that anymore. That is a clear negative. On the other hand, API-based data sharing ecosystems, they're a lot more easy to work with if you actually want to set up a valuable, flexible, interactive data sharing ecosystem. If you want to be able to exchange data in multiple ways, not just a one-to-one exchange where one is the data holder making it available to the recipient, but just enabling an ecosystem where very many people can reuse your data and exchange it among themselves and send data back, which is more and more important in the data economy nowadays, APIs are ideal for that. Flexible mechanisms are available for that. And on that point, it's important to realize that APIs, dynamic data sharing, doesn't depend on IPRs. So despite some of the sort of critical observations or the uncertainties that you have on whether certain data sets are actually eligible for intellectual property rights, despite those reservations, that doesn't actually have any implications on dynamic data sharing. It just means that you're shifting away from a more tightly defined and regulated intellectual property rights framework to a more flexible and a more contractually open terms and conditions and subscription-based framework. And it's also, it doesn't override any of the impacts of the Open Data Directive. This is an important point that I mentioned, and I hope that came across during the Open Data Directive presentation. No part of the Open Data Directive requires information to be protected by intellectual property rights, and none of the obligations that member states have under the Open Data Directive depend on intellectual property rights existing. So you can exchange information freely, you can impose contractual restrictions, you can allow reuse irrespective of whether intellectual property rights exist. It does mean, however, that there are some points that you need to pay attention to. If information is not protected by intellectual property rights, then all of those lawful usage rights that are defined in copyright law and the software directive or in the database directive, all the legislation that we have at the national and European and international level, all of those safeguards fall away as well. So it becomes a lot more important to look at whether any intellectual property rights are claimed and granted, and if not, then how usage rights and usage constraints are governed in the contractual framework, how the licenses address usage of specific data if there is no intellectual property rights. It's particularly important if you look at the for highly innovative cases. For instance, if you want to do big data analytics, AI analysis of specific data, it's unlikely that a small company would be able to do that kind of work itself. So it has to be able to access data under terms that allow onwards dissemination. It's not sufficient that I can get information from a database. I need to be able to share it with a third party who will do the analysis for me. I am not an AI expert. I'm not going to be able to do large-scale analysis of big data sets. So that kind of permission needs to be scoped a lot more carefully in terms and conditions in a subscription-based service than you would normally do in an IPR-based license. Also, because you're looking at an subscription-based model where inherently data sharing is done as a service, it's also more important to look at the assurances that you get around that service. So use of service level agreements, to whether you have any guarantees on availability and uptime of your data sharing service, of your API, long-term availability assurances, the capacity, throughput, whether there are any limitations on how much data you can get out of it. All of that becomes much more relevant when you are depending on a model where data is provided flexibly to you as a service. And also, and this is the eternal question for any kind of as a service type model, what happens when someone closes the tap, so to speak? The idea of any as a service model, for data as a service model, is, you can open the tap and data will come out and you can use whatever you need, pay maybe depending on your consumption if it's not free data, and when you don't need it anymore, you can close the tap and your use of the service ends. Right, but what happens when the tap is closed? What happens to the data that you've received? Are you required to delete it? Are you required to stop using it? Can you retain it? Are you allowed to continue to use historical data? Those are kind of questions that wouldn't pop up as frequently in traditional IPR-based models, which, you could also write those kinds of constraints in an IPR model, saying, I grant this license to you to allow you to use this as long as you're paying this particular copyright license to me. But it's not something that was inherent in the philosophy and the logic of IPR-based data sharing. And in a service-based data sharing ecosystem, those kinds of considerations become a lot more important. If you want to have long-term access to data that's been made available as a service to you, then it becomes a lot more important to get assurances on whether you're allowed to use it and for how long you're allowed to use it after use of the service ends. So yeah, sort of the big conclusion there, and the main trends I think are clear. So we are moving gradually to a dynamic data sharing model, data being provided as a service rather than in a more static model. I think it's also clear that there are a lot of benefits in there. We see that there's a lot of legislation, increasingly more legislation that encourages this kind of model. This is a model and approach that possibly relies less on intellectual property rights than older data sharing models. But I think it's also clear that that doesn't necessarily need to be a problem in data sharing practices. It does mean that some homework is necessary to see what can be done and what cannot be done. But it is, I think, an exciting trend that organizations, both in the public and private sector, need to learn to work with, and where they need to have more attention to how they scope their terms and conditions, how they scope their contractual frameworks to reflect the fact that they are now no longer just licensing data, but they are actively service providers. And that requires a little bit of a different mindset. Okay, that's the presentation section of today's training session. So it was I'd say the less interactive part. We already have a couple of comments that have been put in the chat. I will be very interested to look at those in a moment. We will first have a short coffee break to allow you to catch your breath and to grab a quick coffee. Let's see, we're about 5 minutes over time, I think. I think we can stick to a 10-minute coffee break then, and we can start at 3:15 sharp. I see that my panelists are here, so that's great. So we'll have a break until 3:15. I'll put the exact moment in the chat for a moment so that you can watch it. And I'll be very happy to introduce my panelists and to open the floor to any kinds of questions and comments and considerations. Thank you. See you in about 10-ish minutes.
Welcome back, everyone. Hope you have had the time to grab a cup of coffee or something else to drink, and that you're all ready to continue the training. Hans, are you ready for the panel discussion? Great.
Okay, so let me quickly get the names of my esteemed panelists back on the slides. Just a second. I see on the participant numbers that virtually none of you has taken the opportunity to escape, which means you are either legally required to be here or sincerely interested. Either way, it's a good sign. So I'm happy to see most of you still here. So indeed, we are going to start now the second part of the training session, which is a more interactive panel discussion. So I'm going to pick up on some of the questions that were raised in the chat as well. I also have my own questions prepared for the panelists, because there are a couple of things that I definitely want to pick their brain on as well. But we will be picking up on the questions that you will have in the chat as well. So feel free to raise them there, or feel free to unmute whichever of you are most comfortable with. So before I do that, I just want to give give the panelists the opportunity of introducing themselves briefly. So I have two panelists I mentioned already here in the introduction. Unfortunately, we had one panelist that had to cancel due to an overlapping commitment at the API Days conference, which is important because it strengthens the story that we've been telling you here, that API-based data sharing is a very important and very big thing. So big, in fact, that there are 2 European events ongoing at the same time, and you picked the right one to attend. So good job. The two panelists that we've had, I've had the extreme pleasure of working with them a couple of years ago and many years ago already. So I know that they are both very knowledgeable and very experienced experts in their field with a lot of interesting things to share with us. Also interesting because they both don't bring a uniquely legalistic lawyer perspective to the table. They have more practice-based experiences in supporting governance, public administrations, portal operators, data portal operators, so they have a lot of good information for us. I will maybe give the floor to each of them to present themselves very quickly, and then we'll move to the questions here. Let me just quickly see. Yes, Annette, you are there, I see. Would you like to introduce yourself?
Yes, thank you, Hans. Good afternoon, everyone, and thank you for the invitation to the session. I hope you hear me well.
Perfectly.
It has been very interesting so far, and I look forward to contribute to the discussion from a view of local governments. So I'm a social scientist and economist, as Hans said, not a lawyer. And I'm working with WIC for 25 years now. This is a scientific institute for infrastructure and communication services founded in 1982 in the context of liberalization of telecommunications markets. We are working on publicly funded projects, mainly as we are a part or funded by the German federal government, partly, but an independent scientific institute. And in my current job, I'm a deputy head of Stadtland Digital, which means in English, city, rural area digital, a wordplay about a popular children's and also adults game in Germany. This means we work with the Ministry of Economics to support German municipalities to design and implement digital strategies and smart city projects, and mainly on a local, rural, suburban level. As you're maybe not aware, we have 11,000 local governments in Germany, and only 81 are larger than 100,000 inhabitants. So our focus is definitely on the smaller local governments. So we work with all kinds of shareholders at the moment, with groups, associations, and we are giving also consultation to the Ministry of Economics on scientific developments in smart cities. So I would like to share some of the experiences we had with these projects, and I'm looking forward to your question and the discussion.
Excellent. Very glad that you could make it and you could join us. I'm certainly interested also in hearing more about, well, precisely perspective from local administrations as well, because it's, there's often a big jump between talking about all of the policy priorities and then the legal frameworks, and then looking at what actually can be done and should be done and will be done at the local level. But before we dig into that, maybe I'll pass the floor to Ton Zijlstra first, if you'd like to introduce yourself as well.
Yes, good afternoon, everybody. Thank you for having me, Hans, and inviting me to this panel. I've been active in open data and helping government entities to do open data for 13 years now, both on the EU, national and local level in different places. Last year I was involved with the advisory study for the European High Value Data List, where I led the research on Earth observation, environment and meteorological data. And next to doing all that from my own company with a number of colleagues in my spare time, I also work for the World Bank as an open data expert, usually involved in creating national open data plans, action plans. And I've mostly been active in Central Asia, former Soviet Union. And my current role is that I'm with Geonovum, which is a knowledge network organization of the Dutch government centered around the implementation of Inspire and standardization. There I am supporting the Dutch government in helping to translate the new wave of incoming legislation based on the digital and data strategies, to translate that to new tasks and also opportunities and maybe obstacles for Dutch government data holders.
Excellent. Thank you very much. Okay, It's interesting. You will, by the sound of it, despite the fact that you have, you work in open data, both of you, I think would expect that you would have very different perspectives and different experiences on how policy can actually affect data sharing in practice. Going to go over some of the questions in the chat, but before I do that, I have one sort of an introductory question for both of you, which really relates to how relevant all of this discussion is. So I've spent some time talking about the move to data as a service and dynamic data sharing and on APIs. I guess the two questions I would like to ask both of you, see what your opinion and experience on that is, first of all, whether you see that shift in reality already, as I think, my stereotypical interpretation of your introductions would be that, Ton, you would be looking more at sort of the strategic and more voluminous, I would say, sort of bigger administration data sharing. So I'd imagine that you would think maybe more yes. For Annette, because you're working more with local administration, my bias would be to say, well, probably they follow it less. So first of all, I was wondering whether you see this shift to data as a service and the APIs, whether you see that already. And secondly, maybe as a related comment, do you think that a regulatory push the way we have in the Open Data Directive, that actually helps, or that this was going to be happening anyway, no matter what legislators would do? Maybe ladies first. I don't know, Annette, if you have immediate comments or reactions on that.
Yes, thank you, Hans. Well, as you asked for a more pragmatic or realistic estimation on this, I'd rather say that based on our experience with the work of German majors, and especially with the chief digital officers located in local governments that are responsible for digitization in many aspects, not only e-government but also smart city projects, and they often form a hub in the local governments and coordinate all these also open data projects. I frankly do not see this at all, that they are working on data as a service project. They are very much consumed by the basic question if open data will support the smart city project, in what way they can form maybe a local data platform. They do projects with sensor technology, for example, with LoRaWAN networks a lot. This is some of in many cities. And then they ask themselves, okay, will we have a dashboard? Who will use this? Who is responsible for it? And then maybe this goes a little further and they say, okay, we have some data that could be useful for others as well. And often this is on an experimental stage, and a starter is often also the civil society that does a hackathon in the area, in the region, and then they get ideas from working with open data. So, and if you say, is there a legal push, then I have to say that as we do, I maybe add that we do a lot of workshops with chief digital officers every month. They do reports on their progresses in a closed community of digital officers, and what they say is, or most of them are really not aware of EU legislation on this. So this is of course because we have these 3 levels in Germany. The communal level is independent, subsidiary, and the federal laws do not affect them per se. So, and then we have the lender in between that should translate everything down. So yeah, but when they do this, they are very keen, and they do it for their own benefit and with their own ideas.
That's actually, it's an exciting answer, because the bottom line is really that the focus is more on building applications and making new things happen. And the fact that it's done through hackathons and building dashboards and building applications around that means that it's sort of there's already the intuitive and spontaneous shift to using APIs and making data available and sharing it more easily. So you can't say that the legal framework is effective if people don't take it into account when making these decisions, but at least the shift that the policymakers would like to see happening is happening. So that's an encouraging one, I think. Ton, maybe your perspective on this.
Yes, two starting points, I think. One is that that I, in the past year, started looking at the combined picture that all the new EU legislation initiatives form, so that the geopolitical proposition that the EU is formulating with not just the Open Data Directive, but also the Data Act and the Data Governance Act and the AI Act and the Digital Market and Services Act. And within that context, what I notice is that a lot of public data holders still think of open data as, okay, we provide a download and that's it. Most developers on a practical level for years have been asking for APIs and more interactive ways of querying data and didn't want to bother with those downloads. But on the policy level, what I've seen is that there are specific policy areas like energy transition, like climate adaptation, where the government is now realizing that the relevant data is held by a wide range of interdependent, both public and private stakeholders, and where there is a lot of uncertainty with regard to data sharing or data pooling. And in that context, being able to specifically query through APIs or using a service to combine data into something that can lead to a decision is of high interest, mostly because, for instance, when it comes to energy transition in the Netherlands, it's the provinces that have the responsibility to achieve the policy goals, but they have really no power to move to make anybody move in that regard. And all the relevant data is with other entities, the network maintainers, the building societies, the smart metering things. So in that context, the services are much more interesting, and there legislation does help because public undertakings are now within scope of the Open Data Directive. That's very helpful because that gives them also a mechanism, at least to the ones that want to, and a lot of them do. The Data Governance Act is also helpful because it brings the non-public PSI within scope of looking at how can we use that, can we take benefit from the existence of that data. It introduces data altruism, so that's really helpful. And the forthcoming Data Act is also probably really helpful with the conditions they will shape for business to business and business to government data sharing. In total, that reduces a large part of the uncertainty that is now being felt in those areas where you have many different stakeholders with many different pieces of the data puzzle. And so yes, legislation is helping there also because it's, the data spaces that are the result of all this create, let's say, the new water that we will be swimming in as fishes, and that water was before was absent, so you had to create everything on your own.
I think it's interesting that you both mentioned sort of even in public sector, the fragmentation between the different governance levels, and even if at the practical sort of application building level there isn't awareness of legislation, the fact that you do have cross-cutting legislation helps to harmonize the policies across all of those different levels. So it's interesting that both of you mentioned that, and also that you reference data as the new water rather than the new oil, which I think I think we all need to start doing that. I think we need a carbon neutral terminology to talk about this. So another word that you mentioned, and I'm going to abuse that because it allows me to skip to one of the questions, geopolitical, because this was one of the intriguing questions that was raised during the presentation, and I'm dying to get everybody's opinion on that. So a question raised by Mr. Michel Chaduteau, if I read correctly, is the geopolitical question of what would happen if the EU opens up data to other countries in strong geopolitical competition with the EU, because that's, maybe, I don't know if Mr. Chaduteau, if you are able or willing to sort of explain the background context a little bit? If you can unmute, would be willing to do so. Or possibly not. I'll maybe give you my perspective first, and then Mr. Charito, if you are willing or if you'd like to comment, then please feel free to do so. Because it's indeed, I don't know if you have any, I don't have any perspective on that, but I'd be curious to see if you have any perspective on that. The consideration that the public sector has to have a policy on data sharing and has to push the market to make data available. I don't know how uniquely European it is, but it feels very uniquely European to me, but maybe that's because I'm not studying outside of European borders very much. But you do get to a situation where European data is made more openly available, and none of the legal frameworks say what it needs to be available for access and reuse to Europeans or to European universities, to European companies, to European citizens. So I guess the question in a very real way is, are we giving away the crown jewels? Are we being naive? I don't know if I guess maybe it's more of a question for Ton, also because of your international work, but Annette, obviously your opinion on that would also be welcome.
Well, naive, I don't know. And you know, if you zoom in, then yes, of course, pre-existing technology companies that are already rather dominant in the market are probably better positioned to adopt the usage of data when it becomes available. So Google will be eager to immediately pick up on public transport data in a way that other companies might not be able to. So in that sense, you might be giving something away, but in general, I think the position that the EU is now taking is that we want to do two things. One, with our legislation, one is to maximize the benefit of having data available and using the opportunities that digital affordances give us. And second, we want to do that in the context of not just only protecting, but also strengthening civic rights and democratic control. And the way that translates is that, you know, things like access to the European market are getting tied to these norms. Yeah, and within the AI regulation, that's most prominently visible. And the impact of that is that you're actually exporting, like we've done with the GDPR, these specific norms and attitudes towards data to the rest of the world, and they will be adapting to it. So in the short term, maybe yes, certain companies well established across the world will be able to pick up on data opportunities maybe more quickly, but at the same time, it will also force them to adapt to the conditions that come with that, and it levels the playing field for all others as well, which is now definitely not level.
Mm-hmm. That's really a case of where, you know, even though you don't know if you'll wind up being the playmaker in the end or the one who builds the most exciting applications and services around that, but the consideration is, if as long as people who are using your data are playing according to European rules. You mentioned AI regulation. GDPR obviously is another very clear example, but we might see more things in the Data Act. Then ultimately it will benefit the European economy at any rate.
Yes.
I don't know, Anna, does that mirror more or less your thoughts and experiences on that, or I don't know to what extent that this has encountered something in practice really for the geopolitical context. I would guess maybe practical stakeholders.
That's really far away. I think in at least 10,000 of these communities, and I think in other countries it's the same thing, obviously. But I don't think that people who work on open data projects are naive. But they are hopeful and wait for someone to pick up the opportunities. Local startups would be the ideal case, of course, or local companies. But if someone would pick up on these local data and create something and create a business case that is valid and is sustainable, that would be the first thing they hope for. And I don't think that they expect Google or someone to pick up on this. And maybe if they would do and create something that is really relevant on a local level, that would be welcomed. I don't think that there is, at the moment, that there is fear in this field.
Mm-hmm.
So,
it's comparable to what you've seen. Well, what you see in non-public sector data sharing, I guess. If you look at something like like street information, people might be inclined to go to Google Maps or to another big company operated system, and they have more information and more ways of unlocking it. But to actually tie local knowledge and local understanding to that, that's something that a local partner can do better. So this is really more of an example of an ecosystem where, yes, a big company might be able to capture a lot of local data, but in turn, that also allows local companies, again, to build services and products on top of that. So there might be a win-win there, even if it's not a symmetric one.
One example would be that Google Maps, when it comes to route planning, does not understand the way that cycling or walking works in Dutch society. So they routinely come up with routes that make no sense at all because they don't understand how those road networks operate in the Netherlands. And so that would be an example. One of the things, Annette, you said there's that sort of the geopolitical aspects might be quite remote for local settings. One of the things that I do try to do, for instance, with municipal geoinformation advisors within local government is to impress on them that what they are doing also is part of this geopolitical scene setting, not to scare them, but to make them see that what they are doing or the conditions under which they do their work also creates new opportunities in a much wider context than they might be used to.
Yeah, right. But yeah, on the other hand, if you look, for example, on sensor data and predictions, and maybe on extreme weather forecasts, which is a big topic at the moment everywhere, and especially in Germany, as we experience this catastrophic rainfall in the Ahrtal, I think they would first see the opportunities to match local data against maybe a bigger data pool and have more valid forecasts on this. So I think, well, but this is they would they see the most obstacles definitely in data protection and then a little bit in intellectual property rights, but this perspective is not yet there. But you're right to put it on the list also for local governments.
It also ties in more or less to, it's a question from Mr. If Martin, if you're available or interested, and if you want to explain the question, it would be very welcome, about monetization options, about what actually, well, the direct question is, how do you monetize data and what are the models behind that? I think the related question is, because what we're talking about so far, and hi Martin, what we're talking about so far is more about valorization, creating value from the model, from data, and your question is more about monetization. But maybe I'll allow, if you would like to phrase the question yourself.
Exactly. Thank you for this opportunity. A very nice hello from snowy Vienna, Austria here to everyone. Actually, yeah, I also don't want to talk that much about monetization and these kinds of words. You're absolutely right. It's about the valorization of data. But the question is kind of what vision do we need if we want to have most of the value of data available? Well, there are some people, of course, the best way should be at first hand to open data. Well, yes, to have it as open data and to make everyone aware of the fact that open data is the best form for reuse of data for everyone, for public interest, so to say. But I see it here also in my country and so on. There are many people who are still stick to the idea of data ownership, and they need to protect their own data, and it's not possible to give it fully freely into a pool. So kind of, but I know it's a quite complicated question, but what vision would we need in order to make these potentials available in certain ecosystems? What ways do we need to explore? Are IPR rights already out-fashioned, or, well, shall we strive for subscription models, or what do you see? What tendencies do you see for the future? What trends are upcoming, and what would the best possible ways be to share data commonly? Thanks a lot.
Thank you. I have my own ideas, but I don't want to impose them, so I'm going to do what I'm supposed to do and ask the panelists whether they would like to comment on it first. And if not, then I'd be very happy to inject my own ideas. I don't know if you have any immediate thoughts on that, Ton or Annette.
Well, some, probably also highly opinionated, but I think that the question of especially in the public sector of charging for data access, in my experience, usually has two backgrounds. Either because they are let's say operational entities that sometime in the 80s or 90s, were forced to cover their own costs and not be financed from the central budget, or it is a placeholder argument for different types of worries or fears. What happens if that data is freely available? You see that with the company register in the Netherlands, for instance, where they say we have to charge, otherwise people will do criminal information and do criminal acts with the data about ownership and that sort of thing, which of course makes no sense at all. It just means that you already have to have a starting capital to be able to buy the data so that you can do your criminal acts. So there's no logic there.
Exactly. You need to be a well-funded criminal, basically.
Exactly. And it's not your average street criminal that can access the company register, but anybody else can. And when it comes to monetization, specifically when we're talking about, let's say, monopolistic data sets held by the public sector that are mandatory for people to register themselves in or be registered in or mandatory to use, then monetization at the point of access makes no economic sense whatsoever. The only problem is that the benefits of opening it up usually do not accrue with the data holder, but with the Ministry of Finance in the shape of additional tax revenue. So it needs to switch to the general budget. But the underlying fears normally are the ones that take more time. And the way that I've been doing that in the past 13 years is to bring data holders in touch with the stakeholders that are eager to use their data, and to show that these are two professionals that want to solve certain issues. And we've seen that with the Dutch Statistical Office. In 2009, they said, you know, Ton, we are the only ones who understand statistics in this country. We're not going to open up any of our data because they will have to come to us for the right explanation, and everybody else will just make stupid mistakes. Until they realize that there's a wide community out there of people who are well versed in statistics, who are very eager to use that data, and now they have a lively community of reusers that actually provides lots and lots of feedback that improves the functioning of the Central Statistics Office as well. So that's a lot of my effort in the past 10-15 years has been bring stakeholders to the table so that you can recognize each other as professionals in your wishes and needs and demands. And then within that context, usually data sharing is very much okay for all involved.
So the experience is very much about bringing stakeholders together and facilitating the communication, because to convince people that there is a value that's part of the value, even the added value, will land with them as well if they make data available. Not in the sense of euros on your bank account, but in the sense that you will get insight or get functionalities or products or services or whatever that you would not be able to create yourself if you kept your data internally. Indeed. I'm going to quickly see, because I see a raised hand. I will maybe, I see that Mr. Jean-Paul Triaille has a comment or a question to make.
Yes, if I may. Hello, everybody. And thanks, Hans, for this very good presentation. I haven't read your paper yet, but I'll definitely do so. And I had maybe more an observation than a question, actually. First, I'd say, you were talking about the fact that maybe we were moving from an IP-based system to something else. I would first say, don't count IP out too easily. As we know, IP has a sort of resilience and elasticity to it that makes that it remains fit for purpose, or at least it remains existing over the years, even though everybody thinks, and I've heard this story for 30 years now, that our IP is outdated, IP is going to disappear, etc. So don't count it out too quickly, I would say, even though I agree that we do tend to see a shift out there. But maybe what I would say is the shift certainly is, in concrete terms and technical terms, very much a shift. You could summarize it from an offline distribution of software, data, and whatever to an online distribution of data, service, etc., which of course makes contracts a powerful tool, but also to a certain extent a bit, I'm not going to say a dangerous tool, but still a very powerful tool to keep control of the assets and keep control of the access to. And my observation would be, I guess, the following. Whereas intellectual property rights and copyright has always been, or has been, the result of, a social compromise, and is a combination of exclusive rights plus all sorts of exceptions for research, for private use, for a number of beneficiaries of exceptions, and behind each exception you have a sort of a public interest or a social interest behind each of them. If we are indeed, and to a certain extent, yes, we are moving away from a purely IP-based system to a more contract-based and access control-based system, then all these exceptions under copyright may end up being less efficient in guaranteeing access rights, which I think, and that's my observation, which I think makes the issue of access to data, not so much voluntary data sharing, but access to data, more and more important in the future. We know it's one of the issues that will be addressed in the Future Data Act, but I would say indeed, rightly so, because it is, to me, more and more a key problem there. Under which circumstances can a third party require sort of a compulsory access to certain data sets? So that would be sort of my observation overview.
I welcome that very much, also because it kind of you're helping us back to the core topic of IPRs, so which we're kind of straying away from. No, and actually I can only agree with that fully. I think also, first of all, that's because this entire session is about data sharing, and intellectual property rights. In the creative industries, I don't think there's much discussion about alternatives, and people don't really know about them, and they're just saying, don't discount IPRs, get rid of copyrights and go for contracts. Create so many problems it's hard to even begin to list them. I think what I find interesting is in that the data economy specifically, my perception, but I'd actually be interested in hearing your opinions over the panelists away. Also is that the discussions about IPRs and data sharing, the data economy, public sector information, but also inversely in data sharing from private companies to the government, is less about intellectual property rights and more indeed about scoping access and usage rights. And even in legislation, because I had some slides with various examples, none of those really focus very much on copyrights, other than to say, intellectual property rights are left intact, copyrights and patents and whatever, we don't touch those, but these are access and usage rights. So it might be a trivial observation, but I think particularly in the data sharing context, it's interesting to observe. That's my observation and not necessarily the truth. So I invite people to disagree. Then people are indeed more inclined to look at, what are the access and usage rights that we need to implement to get good policy outcomes, and to move away from intellectual property rights discussions, which really have enabled a lot of progress, but also have created a lot of discussions where honestly none needed to be. And I think that's more or less my observation. And again, that's, in my young years as a student, I probably was more critical of intellectual property rights, but I've kind of grown fond of them over the years, and I've learned to see the benefits. So I think more broadly, intellectual property rights are not down and out in any way, shape, or form, but specifically for data policy and for data sharing, there seems to be a shift away from them, is my impression.
Mm-hmm.
Yeah.
Thanks.
But maybe I wanted, because that was another question I kind of wanted to ask the panelists or anybody in the audience as well, because everybody may comment on these things, obviously. It's actually just how often do you encounter intellectual property rights discussions? Because if my sort of theory is correct, that it's actually more about access and usage rights and not about formal copyrights, about intellectual property rights, copyright and database rights. If that would be correct, then you wouldn't have a lot of discussions about people saying you can't do this because of copyright or because of database rights. So I'd be interested in hearing what your experiences on that would be, whether you actually encounter intellectual property rights a lot, or whether indeed people talk more about, it's about negotiating appropriate access and usage rights, irrespective of how you frame them. I don't know, Annette or Ton, whether that sort of thing comes up. I know you're both not lawyers, so it's probably a little bit hypothetical, but I'd still be interested in hearing your experiences.
Yeah, well, I would like to make two brief comments maybe on this. There's also, we didn't speak about the intermediaries local governments use for data processing. They were well established. They have contracts, long-term contracts with these governments. And of course, they look at their business cases and, so to speak, intellectual property rights. They might sell validated data if there's a market for this, and where it definitely will become more important step by step. And this is, in my opinion, this is a case even if local governments provide the raw data, because a lot of companies would not like to reuse raw data. They would prefer to pay for the validated processed data in a way. And then we also have the case for in the e-government space and smart city space of Gaia-X. We didn't speak about that there, but there are emerging projects, experiments, thoughts about how to have data sovereignty within the Gaia-X space, so to speak. So this might be solve some of the intellectual property rights discussion, as you can have rules within these environment.
Mm-hmm. So it's basically about, I'll pass the floor to you, Ton, in a moment. But I think the point is, first of all, that we shouldn't underestimate the role of intermediaries. Also because, and I think you're right in pointing this out, all I've talked about is data as a service, but I think you're right in saying it's not just data as a service, it's also the services surrounding data. I don't just want people giving me data, but also increasingly I would be interested in getting people who can provide me services around that, which can even be things like, I guarantee the accuracy, or I will provide you with more, I will enrich the data, I will cross-reference it with other sources, or just things like that, that it's not just data as a service, but service surrounding the data and the economy. And I think the other point, the data sovereignty point, it's not strictly IPR related, so it hasn't come up very much, but I think it's also interesting because of the geopolitical question that was raised earlier on, is exactly that question, to what extent can we get more data sovereignty or strategic autonomy, which is sort of the other buzzword that's very important right now, making sure that data does get shared without necessarily abandoning the possibility to be self-sufficient. Tons of different topics to touch about. I'm thinking we should have a different session about that, but that's maybe not strictly IPR related. Ton, I was going to give you the opportunity of firing back still as well.
Yeah. Several observations. in practice, when I encounter discussions of IP rights, then it, especially with public sector bodies, is often in the same way that I encounter monetization discussions, which is it's actually sort of a placeholder for other fears and objections against data sharing. So positioning the discussion in terms of access rights is very important to me, because that then it becomes a let's say a less asymmetrical discussion for me as a citizen with my government about the data. I also find that in a lot of discussions, the discussion about data ownership is also well, slightly toxic, I would say, because often it appears to me as an attempt by, let's say, commercial data users to put my data, my personal data, or other data that I have, in their context of, it's all about, property and it's all about ownership, and then we can sort of haggle about the price, which again, it's tied to rights, and so it seems like a shift in the discussion. All that being said, of course, it's an issue, especially within context where data is being pooled. Just this week, I had a discussion about the Dutch national database of flora and fauna observations, so species observations across the country. And this is a national data set, a national registry, where volunteers, nature conservation bodies, public sector entities, and many others contribute their data. And in that context, it's highly relevant to discuss whether IP rights are not in play, yes or no, and to sort out how collectively you can have that data being used to the type of benefits that were the reason behind starting to collect the data in the first place.
I think it's an interesting point, and honestly, now that we're at the end of the session, I find it kind of surprising that I didn't really lead more with the issue of data ownership. Well, it's also because as a lawyer, the concept of data ownership, it borders on hypnosis. It's something that you say to suggest a feeling with people without anybody actually understanding what it means or what it implies. It's like, agree. You can own your data as long as I can access and use it any way you like. Feel free to enjoy your ownership then. So yeah, it's a complicated notion, but that's food for another discussion, I think. Unfortunately, I mean, I'm massively enjoying the discussion, to be honest, but unfortunately we're more or less at the end of our timetable. So I think I'll be very happy and grateful to thank the audience, but also in particular, obviously, our panelists for contributing and for the very valuable opinions. I think it's been an interesting discussion. I would encourage anybody, get in touch with us if you have further feedback or suggestions. Also for future topics, we have a couple more training sessions lined up, and I think they'll all be quite fun and quite interesting. At least we'll do our best from our side. If I did it correctly, there's also a feedback button on your screen right now with a QR code that's probably massive, so that might not work very well. But hopefully you can scan it and provide feedback to the session, which would be very, very much appreciated. And yes, meanwhile, I'd like to thank everybody for participating and for making it a fun debate. I think I learned a lot, which is maybe not the objective, but at least a fun side effect.
Thank you very much, Hans.
Yes, thank you very much, and thank you, everyone.
Thank you, everyone. Have a very good afternoon still.
Thank you.
Bye-bye, everyone.
Bye. Bye-bye.
Thanks, everyone.
Bye.
Bye.
Goodbye.